Hello, everyone. We'd like to thank you for joining Dorsey and Whitney's webinar today, which is about understanding the SEC's new mining disclosure rules. My name is Chris Doerksen, and my co-speaker today is my colleague Kimberley Anderson. We're partners in Dorsey and Whitney's Capital Markets and Corporate Compliance Practice Group, both based in Seattle, Washington. We're excited to speak with you today because we've been working with mining companies for a combined 45 years, and these changes have been a long time coming. But first, a few housekeeping matters. Today's program is scheduled for 60 minutes in length. If you would like to receive CLE or CPD credit, please return the sign-in sheet that should have been included in the reminder that was sent to you yesterday. For those of you admitted in New York, partway through the presentation, we will be announcing verbally the New York CLE code. And questions. We're going to try our best to leave some time for Q&A at the end. If there's any questions that you would like to address, if you are connected through the web, there should be a chat feature where you can submit a question there. We will try to address those questions at the end. If we aren't able to get to your question, we will try to follow up with you separately after the presentation is done. Okay, so let's get down to it now. As a brief overview, we're going to talk about four things: a little bit of background, then the new rules themselves, what they will require, a summary of how the new SEC rules differ from Canada's National Instrument 43-101, because we know that a lot of you are subject to those Canadian rules right now, and then implementation, what to do and expect as you move forward, getting ready to comply with these rules.
All right, so let's first chat about what everybody is currently subject to. So all the current disclosure is currently governed by SEC Industry Guide 7, which covers mining operations. So Industry Guide 7 dates back from 1982. So it's been around for a while, and it's certainly showing its age. And it had not been updated until the most recent rule amendments, and that were finally adopted in 2018. There were some proposed rules in 2016, but there had been quite a bit of requests for updating from the industry, in the United States. Because while the SEC has its very specific Industry Guide 7, other jurisdictions had been adopting standards based on the Committee for Mineral Reserves in their International Reporting Standards, otherwise known as Crisco. So Industry Guide 7 is unique in the fact that it doesn't recognize resources. As far as they're concerned, they don't actually exist. It only recognizes probable and proven reserves. So there are some standards for reserve requirements. The reserves, the ore has to be both economic, legal to extract, assessment of the likelihood of permitting. Your economic analysis can't use a commodity price greater than the 3-year trailing average. So for some commodities that have been seeing a significant uptick, or it's forecast to have a significant uptick, this is problematic. And then unlike Crisco, it requires a final feasibility study to be able to declare reserves, not just a pre-feasibility study. There are certain exceptions to that, but we won't go into it. So there was, on the flip side, to make life a little simpler, there was no requirement for a qualified person review of technical disclosures, or a requirement to publish technical reports. The rules only applied to your core SEC filings. For example, if you're a foreign assured 20F or a 10K or a 10Q, and it would not apply to things like website disclosure and otherwise. The only people that were allowed to make non-compliant disclosures, there was what's called a foreign law exemption. But as far as the SEC was concerned, the only foreign law that actually existed that permitted disclosure was 43-101, adopted in Canada. Everything else was either a stock exchange guideline or otherwise, which as far as the SEC was concerned, didn't permit you to make non-compliant disclosures. So Crisco they worked on it for 20 years toward international standards. So it was, published. They published the international reporting template for the public reporting of exploration results, mineral resources, and mineral reserves. There are codes based on Crisco all throughout the world. JORC, 43101, SAMRC, et cetera. The U.S. at one point had a guide, the SME guide, but the SEC never adopted it. So it wasn't something that was adopted that could be used and recognized by the SEC. So key features of Crisco was the concept of a qualified or competent person who's educated and trained. Your scientific and technical information had to be attributed to a QP. It recognized both resources, indicated, measured, as well as inferred, and mineral reserves, the probable or proved or proven. And then you also had to have technical reports to support your disclosure. So here's the problem. Unless you are a Canadian company, so we're going to set Canadian companies aside because they had a bit more leeway. What it really meant is that if you are someone who's filing, your reports in the United States, you could not include disclosures other than permitted by Industry Guide 7. So it placed significant limitations on your disclosures. You couldn't put in mineral resources. And so companies were putting their mineral resources on places like websites, press releases, and so on. But it wasn't contained in your annual reports. So this placed U.S. issuers at a significant disadvantage. And there was always a concern that SEC reports omitted material information.
Yeah, it was kind of an awkward situation where the SEC was specifically prohibiting companies from including the most material information to investors, which was awkward in a prospectus offering.
And one could say that it also violated the SEC's own rules that require everything to have, you may not omit material information. So there was a significant problem.
So as a result of all of this, U.S. mining industry was not happy. The SME, which is a U.S.-based industry group, petitioned effectively the SEC, asking them to please, please, please change the rules to make them more akin to the rest of the world.
There was begging involved.
So in 2016, the SEC finally proposed new mining disclosure rules. And the most important thing about that was the SEC finally, agreed with the concept of Crisco and having a Crisco-based system where you had QPs responsible for the most important scientific and technical disclosures. You would allow U.S. companies to disclose both resources and reserves, and you would require the preparation of technical reports that would be publicly filed and available to all. The problem with the proposed rules for many of you who were following this is that the SEC could not help themselves from tinkering. So they started with Crisco and they made a little change here and a little change there, and pretty soon it was very complicated and had a whole host of ways in which it was different from other Crisco-based codes like 43101 and JORC. And so many of the people who commented on the rules were really pushing the SEC to simplify, to have as few differences with the other international standards as possible. And thankfully, that is what they did. So for those of you who are familiar with the proposed rules, here's where you get to sigh as we go through all the things that they improved in the final rules. So for those of you who remember the 3-year trailing average requirement to estimate reserves, the proposed rules had said, we'll make it easier for people by making it a 2-year trailing average, which would have meant that it would have been inconsistent with what people are doing in other countries and would have put companies in the position of potentially having 2 different reserve estimates. So they got rid of that. Now there's flexibility in the final rules about the commodity price you can use. It can be a reasonable price. So it should be workable with other schemes in other countries. Right.
So you can use forecasted numbers. So it does still have to be reasonable. You can't just randomly make up a number.
Right. So another one was that in the proposal they had proposed that inferred resources, which is the lowest level of certainty as to their existence, those resources were not certain enough to be able to be included in an initial assessment, which is the SEC's equivalent to a Canadian PEA. They changed that in the final rules, and now it is permitted to include inferred resources in that economic analysis, as long as you do some other things in the report. Another one was they had a comment in the proposed rules that had suggested, while usually you could declare reserves in a pre-feasibility study now, there might be some high-risk situations where they would not let you do that. They've backed off of that in the final rules, so now you can always use a pre-feasibility study to declare reserves. And then on technical reports, a number of people did not like the idea of having to do a technical report on a material property if you weren't yet far enough along to have any resources and reserves. And in the final rules, the SEC changed it so that if you don't yet have resources, a technical report is optional. So in that respect, it's a little bit more lenient than 43-101 in Canada. They got rid of a lot of bright line thresholds that they had created. There's a lot more use of materiality standards in the final rules. They reduced the numbers of specific tables and things that would be just a pain in the butt to deal with on form compliance. So it's a little simpler. They also have clarified the obligations of royalty holders. Royalty holders are allowed to omit information that would be required if they've tried to get it and they can't get it without unreasonable burden or expense. And so that's going to be really helpful to royalty companies because they often don't have access or control to force a report to be prepared. The SEC also made it clear in the final rules that you can have more than one qualified person to divide up different responsibility in sections of a technical report, and that if a qualified person relies on the issuer for certain types of information that are outside the knowledge of the qualified person, like what does the issuer plan to do, or certain types of macroeconomic information, they're allowed to rely on the issuer as long as they specifically disclose what they're relying on, and then they're not going to be responsible for that. So the final rules themselves were adopted on Halloween of last year, completely replaces Industry Guide 7, replaces that with a new section of Regulation SK, which is subpart 1300. We have a couple of years for companies to get ready for these rules. They're effective in 2021. What that means exactly is a little confusing. So for people who are not going to be doing a public offering in 2021, the SEC has said you have to comply with your first fiscal year beginning on or after January 1st of that year. What that means is if you're a December 31 year-end company, your annual report that you file in early 2022 will be the report where you have to first start complying. But then they also said that if you file a registration statement with the SEC on a form that's covered by the rules at any point in 2021, you have to comply in that filing. So companies could have to start complying really as early as January 1, 2021.
Yeah. Now, we've spoken to the SEC on this point because, in my personal opinion, this is nonsensical. And I was discussing it with them. They are currently collecting questions. He acknowledged that, you know, it does seem the concept of when you'd have to start preparing with the sort of differentiation between when you first have to start reporting in a 10K versus, you know, when you have to, if you're doing a registration statement or an offering in 2021. So we're expecting additional guidance from the SEC, but we don't know when. They're currently focusing on trying to get the Edgar system updated to be able to take a lot of this information. But I'm kind of guessing before the end of the year we'll get some additional guidance with respect to how some of this impacts companies on effectiveness and when they logically really have to have it ready.
Yeah, I mean, as an example of a situation that's not clear, you know, they've said if you file a new registration statement in 2021, you're covered. But what about people who have shelves? So does that mean this, you know, two different companies doing a public offering on the exact same day, one is subject to the rules, but one is not because it's under a shelf they filed a year earlier. We'll just have to wait and see exactly how that will work. And I think in the absence of clear guidance, you may find underwriters and others just wanting to see that disclosure in there because no one will want to take the risk that, oh, none of this is material, so let's just ignore it for another year.
Yeah.
Okay, who is subject to these rules? Key issue. So it's all SEC reporting companies except for Canadian companies that file exclusively under MJDS. We'll talk about that exemption a bit more later. But all of those companies are covered if they have mining operations, which includes exploration and royalties, that are material to their business or financial condition. And it also covers people who do a Regulation A offering, which is kind of an SEC mini public offering that a company could do without being a full SEC reporting company. But basically, it's only public reporting companies. The most important issue for our Canadian friends is that the SEC has eliminated the old exemption that Kim talked about, that once the new rules take effect, if a Canadian company files on a Form 20F or a 10K, it will no longer be allowed to present NI 43-101 information in the filings unless that information also complies with the new SEC rules. So that's going to be the key thing for any Canadian company who is or may be subject to filing on those forms over the next 2 years to make sure that you reconcile and have your disclosures comply with both schemes so that this doesn't cause a problem for you.
But as Chris noted, if you're a 40F filer, this will not be a problem for you in most instances.
Yeah. So a company that is just a private company can ignore the rules. A company that files only under the MJDS system, so the 40F filer that's Canadian, could ignore these rules. But here's some reasons why you might not really be able to ignore the rules, or you might not want to, right? You will become subject to the rules as a private company if you decide to list in the U.S. You may do business with people who are joint venture partners. You may grant royalties to third parties. You may look at asset sales. Any of those kinds of transactions, if it's with someone who's subject to the rules, it would be in your best interest to be able to have a report that they could use. MJDS filers as well, some companies are so big this is a really low risk, but we have had clients that their market caps have dropped and then they're no longer able to file a Form 40F and they have to file a Form 20F. That would be very problematic for you if your reports don't comply and then suddenly on your next annual report when your market cap is down, you have to do a bunch of work. And then finally, for MJDS companies, while this is within your control, there is no exemption if you do an SEC-registered acquisition on a non-MJDS form. And the situation where that would arise most of the time is if you wanted to acquire a U.S. public company on a share-for-share basis, you might have to do a non-MJDS form, in which case the disclosures that are put into the proxy statement would have to comply with the SEC standard. And then I see that I missed, companies can also lose foreign private issuer status. So especially if you're a Canadian company with U.S. operations or U.S. management involvement, if you flip status to domestic issuer, you would become subject to the SEC requirements. Okay, the forms that it applies to is similar to the old rules, except it also applies to 20Fs now for foreign companies. There is an exemption for S8, so an MJDS filer that has an S8 for an option plan or another equity plan, that is fine. You're not subject to the rules for that. But you are subject on the core domestic filings and if you file a 20F. As well as 6Ks that get incorporated by reference into a covered registration statement.
And many times that would be, if it's something material, many times like quarterly filings, or a significant announcement of a new resource or a reserve update, then you want to make sure it gets in your core disclosure because 6Ks don't. Go ahead.
All right, and then what disclosures are exempt from the SEC rules? Again, very similar to Guide 7. Any written disclosures outside of SEC filings are not subject to the rules. So companies will not need to comply with that on their website disclosures, in their press releases, in other written or verbal disclosures, as well as in any 6K or 8K that's not deemed filed and that is not incorporated by reference into a registration statement.
All right, so I am not going to read all of these definitions for you because, one, it would be incredibly tedious and it would just take us too long. So, but we're going to briefly touch on what the SEC now considers a mining resource and reserve. So let's start with a resource. Under Industry Guide 7, there's no definition to look at. The SEC didn't actually believe they existed, so they were not recognized. So under the new rules, again, there's going to be 3 levels. There's going to be measured, indicated, and inferred. These are based on the underlying geological evidence. So it's essentially an assessment of geologic uncertainty, which is the risk related to the quality, quantity, and location of the mineral in ground. So the highest level is a measured mineral resource. Now, a measured resource can be converted into a proven mineral reserve or a probable mineral reserve. So, and then we go to the next level down, is an indicated mineral resource. These can only be converted to a probable mineral reserve because it's a lower level of uncertainty. It cannot be converted into a proven mineral reserve. And then the lowest level of inferred mineral resource is an inferred mineral resource, and it can only be converted to, it cannot be converted to a mineral reserve. It can only go up to a measured or indicated, which at that point it could go into a reserve, but you cannot convert an inferred mineral resource into a mineral reserve. So Industry Guide 7. So this is Industry Guide 7 mineral reserves. This is the current rules that are currently in place for the next couple of years. Same as we had before that we had discussed initially. It would require in order to declare reserves, you needed a final bankable feasibility study. It was based on the 3-year trailing average, et cetera. But these are the actual definitions. And then under the new rules, these are largely based on Crisco. Probable mineral reserve is the economically mineable part of indicated and sometimes a measured mineral reserve. Proven, which is the highest level of reserve, is the economically mineable part of a measured mineral resource. This can only be, as we discussed before, only a measured mineral resource can convert into a proven mineral reserve. As I said, we weren't going to spend a whole lot of time on that. So as we discussed before, the SEC really has moved very much to Crisco Standards because all codes based on Crisco require any public report has to be based on and reflect information and supporting documentation prepared by a competent, prepared by someone who's competent or a qualified person. And so when the SEC came out with their standards, this is to be a QP, you have to fulfill these requirements. You have to be an individual, a professional with 5 years experience in this type of mineralization and deposit. That is somewhat controversial because there is a concern that if you have someone with experience in either a related area but not this particular type of mineralization, there is some concern as to when you qualify as a QP. You have to be a member of a good standing of a recognized professional organization. Keep in mind the SEC will not actually recognize any professional organizations, but nonetheless, they will not be publishing a list. But they did publish their standards of what an organization has to be. So it's recognized by the mining industry. You have to admit members based on academic qualifications and experience. You have to have standards of competence and ethics, continuing professional development, have disciplinary powers, including expulsion power, and provide a public list of members. Not every organization in the United States currently has things like disciplinary powers. So it could be that even very well-known organizations in the United States would not currently qualify as a recognized professional organization under the new rules. So I think we expect that most organizations are currently reviewing sort of their requirements to make sure that they do comply with these.
And one of the interesting things was the SEC specifically decided that it's not going to publish a list of recognized professional organizations, which maybe that's a good thing that they're not trying to be the experts on this, but it really will be the industry and practice that will develop to support which organizations really are recognized.
Yeah. Well, actually, in sort of a weird way, that's why the SEC doesn't allow you to post PDFs, because they didn't want to support a particular company, which is Adobe. And so that's why you can't post a PDF as a file document. So they went to HTML, which everyone I know that has to file in Canada is like, why can't I just file my Word document? But nonetheless, we digress. Moving on to technical report summaries. So there are some very detailed rules about the contents in a technical report summary. I will not read the entire list to you of all the requirements, because it's multiple pages long. My favorite part is that it starts saying that these reports should be in plain English format. So try not to use too many defined terms, technical data, et cetera. I think that's going to prove a challenge to anyone drafting a technical report. But it will include an executive summary, an introduction, property description, accessibility, climate, et cetera, the history of the property, the geological setting, any relevant exploration work, data verification, mining processing and testing, mining, mineral resource estimates, reserve estimates, to the extent they exist yet, mining methods, processing and recovery methods, infrastructure, market studies, environmental studies and permitting, capital and operating costs, economic analysis. Interestingly enough, I find this fascinating, adjacent properties, perfectly logical, but we'll discuss that in a second. Any other data, interpretations and conclusions, recommendations for further work, references, and then, interestingly enough, also the reliance on issuer info. And that goes to some liability issues that we'll discuss later. It used to be, when I commented about adjacent properties, well, perfectly logical to talk about adjacent properties. The SEC always thought it used to have a bugaboo that if you would put a map with your mine and then some really successful mines around it, they'd always be like, you're cherry picking here and trying to make your property look more successful because you're identifying other successful properties around it. They didn't like that. Anyway, but nonetheless, it's now required and it makes perfectly logical sense. So going back to technical report summaries, these have to be signed by a qualified person. This will be included as an exhibit, the summary, to the SEC annual report or registration statement when you're first disclosing mineral resources or mineral reserves for a property that's material to the business or financial condition. You are permitted to report on exploration results prior to resources, and you would have to update these reports if there's a material change in a prior report that requires an updated report when filing a new SEC annual report or registration statement. Now, the interesting thing about this is that it could be, let's say let's say in April, or a calendar year company. In April, they actually announce and they disclose new mineral resources. They don't actually have to file the report itself until their next 10K, which would be filed many times next February or March. So there's actually, under the rules with respect to this, there can be a significant delay between the time when you first announce these and the time when you actually have to file the technical summary itself, which I think is significantly shorter. I think 43-101 is 45 days, as I recall.
Yeah, for the most part.
Yeah. So it gives you dramatically more time. Now, if you're going to be subject to both rules, then you would simply, if you're going to file it up in CDAR, if you have to file your 43-101 report, you would very likely just file it in the United States as well, and it would simply be filed early, just to coordinate those two in terms of disclosure. But depending on when you actually make the report, you might have a significant amount of time to actually disclose it.
Yeah. And what may affect that also is whether you're doing an offering. If you're doing a public offering, even if you technically might not have to file it if you already had a shelf in place, right, I'm sure that your underwriters will require you to file that report before you do the offering.
Yeah. So that always goes to if you're going to be announcing results and you're looking at the summary and it's just not prepared yet, you just need to keep that in mind about when it's going to be coming out, because you don't have an automatic delay period as to when you actually have to file it. So QP consent. They have to sign the consent before the technical report summary is filed. The consent itself is actually only filed if the report is used in an SEC registration statement. So if you just file it with the annual report and it's not incorporated anywhere, the consent itself doesn't need to be filed. If the QP is not an employee of the issuer, remember QPs don't need to be independent under U.S. rules. If it is not an employee of the issuer, you can simply attribute the report to the QP's employer without naming the individual. So if Tom, Dick, and Harry are all employees of the firm that's drafting the report or a section of the report, you can simply name the firm without actually having to list the individuals. Now you'd have to verify that that is appropriate if there's any other jurisdictional codes applying to the report, but under U.S. rules you can attribute the report to a company, which means if somebody changes firms or is out of the country, it's easier to get consent. Then the firm then would have to sign the report and consent. All right, QP liability. So for registration statements, and there is prospectus liability for QP material misstatements and omissions. So in the United States, there is liability for a material misstatement or omission to state a material fact based on a reasonable investor standard. So in this instance, the QP will have registration statement of prospectus liability under the Securities Act. If that makes them nervous, it should, but it's true. It's true. But at the same point, this will probably also create more incentive to make sure it's the firm that's named and not the individual. Now, again, if it's a private placement or a claim based on secondary trading, that misstatement would only be in connection with an offer or sale. As we noted before, you can divide report responsibility among different QPs or the different firms. And you are allowed to rely on information from the issuer. You do have to identify the information from the issuer. And if you're relying on information from the issuer, you're not liable for if that information is incorrect. The issuer is, of course, liable for that. But if you do decide to name a firm, they can't just claim the work of their employees. So the firm can't say, we like Bob and he works for us, but we're just not sure that we're going to take liability for our employees when they did this kind of work.
And the key liability for QPs, that has not changed. That was always the case under the SEC rules. And so that's always been true of QPs for Canadian reporting companies that are cross-listed. This liability has existed. But what you might see develop now is now that the U.S. companies are subject to these rules, you'll start to see the U.S. industry bodies and U.S. firms being a little bit more concerned about this. So you could start seeing more pushback from firms about who gets named and the terms of contracts with issuers. Maybe they'll start requesting more money for consents and things like that once they've completed their work, because I think there will be a higher level of understanding about their liability, even if there's no actual change in their liability.
Right. And I expect that they will try to push to rely on information from the issuer to the extent that they're permitted to do so. And again, that would be something where you'd want to make sure that any information is relied on by the issuer is going to match the various codes that you are subjected to.
Yeah, so if you're thinking of an equivalent, auditors are in the same category, and you think about all the backup procedures that they have, you may start to see QPs trying to get the same level of backup management letters, things like that.
Right.
All right, so what do you have to actually disclose in your annual report? On a 10K or a 20F, there's a few different things. First, you have to include an overview covering all of your properties. You'll still have to include a map for each property, even the ones that are not material, an overview summary of all of your properties, a 3-year production history, and then some tables of your mineral resources and mineral reserves on an aggregate company-wide basis, divided in some different ways, including by commodity, by geographic property, and what category of resource and reserves they fall into. So you've got that overview section that has to cover everything. Kim, a comment that Kim had made earlier, if you have non-material properties, you may just decide, if you're not doing more work on them, that they just don't have any resources and reserves. But if you are going to say that they have resources and reserves, they will have to comply with the new rules, and they'd have to include them in these overview tables.
Oh, and we also recommend, based on sort of experience we've had with Schuler at the SEC, that if you have properties where it's not clear to the reader whether or not they're material, or you have a wide variety of properties, sometimes any concerns by the SEC can be eliminated with a simple sentence that said, the following properties are the properties that we consider to be material. And then you simply list and identify those that are material, or list those that are not, so that it can help the SEC understand, even if you have substantial information about a non-material property, that you actually do consider it non-material, but there's things you want investors to know.
And then after you have your overview summary, for each material property, you need to have a separate section that goes through a number of things, the things that you would expect it to go through: location, infrastructure, history, how you hold title and what rights you have in the property, what work has been done, what work you plan to do, what stage of development is the property at, a description of any buildings, plant, and equipment, the cost or book value of your PP&E, description of encumbrances, material exploration results. One odd requirement is that if you're going to disclose any specific exploration target, a discussion of that target has to be separately captioned, which I think is a little weird, but that'll be a form compliance issue. And then each material property has to have its own separate resource and reserves tables, which interestingly has to have comparisons to the prior year, so that people can just see right in the table how your resource and reserves changed from year to year. So that might be interesting for people who have had a change in the QP, for example.
So, but what if it's the first time? Obviously, you wouldn't have it.
Yeah, then you wouldn't have it.
So it would just be, right.
Yeah. And then as Kim discussed, technical report summary has to be filed as an exhibit if it's the first time that you've disclosed those resources or reserves, or if there's been a material change in the resources or reserves. And if that trigger has happened, then the annual report itself also has to discuss the material assumptions and criteria used in that report. Oddly, that is not required if you filed it in a prior year and there was no material change. But you would have to include that in any year where you did file a report or an updated report. You have to discuss the issuer's internal controls over these matters, including a discussion of the QCQA program and any risk inherent in the estimates that are provided. And then you have to include information about the QPs who prepared any report. You have to identify them, say whether they're an employee of the issuer. If not, identify who their employer is. So you will have to name the engineering firm, even if you have also named the individual. And then you have to disclose if there's any affiliation, conflict of interest, basically.
Do you think this would, we don't have to go back, it's fine. In terms of internal controls and disclosure controls, of course, all U.S. companies have to have both internal control is over your financial reporting, but disclosure controls really go over any material changes. Do you think that these rules, particularly when it comes to trying to determine any material updates or when you'd have to do a material update, would that impact your disclosure controls?
Yeah, I think that it will. So this is a total geek topic, but even though the SEC used the phrase internal controls, that it's not actually financial internal controls in the sense used for the purpose of all other SEC rules, because this doesn't go to your financials. But because it does affect your ability to comply with the disclosure rules, it will affect your disclosure controls. So now whenever going forward a mining company has to certify whether its disclosure controls are effective, those disclosure controls for companies that are subject to these rules will have to include all of the internal procedures to make sure the mining disclosure is done right and done timely. So to the extent you have written disclosure controls and procedures, those policies will probably need to change because they will need to cover things like, identifying which are the material properties, making sure you have QPs that meet the standards, making sure that your technical reports have all the right stuff in them.
Getting back to it then.
All right. So now it's comparing with the Canadian rules, because we know a large percentage of you are used to the Canadian rules, and so it's easiest for you to understand the SEC by comparison. So we've already talked about what's similar. The big picture is all similar. There's some terminology differences to understand. The SEC has used the term initial assessment to talk about the earliest stage of economic analysis compared to Canada's preliminary economic assessment. The SEC has also decided not to call a technical report a technical report. This one's fun. It's a technical report summary, and the thinking, I think, behind that is that, well, conceivably, the more information than that could have been provided to the issuer, but the summary is only the part that has to be publicly filed. So technical report summary is actually the correct term. Comparing with the Canadian rules, here's the key differences. There are going to be some other differences, but we wanted to just highlight what are the biggest differences between the new SEC standard and the Canadian one. So one of the biggest ones is the scope of application. NI 43-101 in Canada is much more restrictive in most areas here. It applies to all written disclosures, not just some. It includes disclosures made to the public by private companies, but as we heard, the SEC rule generally applies only to public companies. And then what has to be attributed to the QP is different. Under the SEC rules, it's actually only the technical report itself that has to be attributed to a QP. And then your other disclosures, of course, have to accurately reflect what the QP said. But in your SEC disclosures, you never have to say that a QP signed off on this or that section of the filing. Whereas under NI 43-101 in Canada, we understand that all scientific and technical disclosures must be attributed to a QP.
Right, which is why you always see the sort of the paragraph on there that says, this was reviewed and approved by so-and-so and so-and-so.
So as a result of all of this, companies that are subject to the Canadian rules, their QPs will be subject to higher levels of liability and more consents will be required, because a U.S. company that's not subject to any other rules could just do the report one time, get a consent from the QP, would not need a new consent for other filings unless you were filing a new registration statement that was including that technical report. One area where the SEC is more expansive is mineral brines are covered under the SEC rules. So if you're one of the few companies in the world that mines mineral brines.
43-101 covers mineral brines.
Does it?
Yeah, but they're the only one who does.
All right.
Yeah.
I'm incorrect. But 43-101 is limited to solids, so I guess they consider mineral brines to be a solid.
Yeah, at one point when I had talked to Schumer about it, I said, mineral brines, seriously? He said, really, they are measured really very, very similarly. They took out geothermal, which made perfect sense.
Yeah. All right. Another difference is that NI 43-101 has a fairly broad exemption to allow companies in certain circumstances to disclose historic estimates that do not comply with the current rules or that haven't been verified as complying. The SEC does not have an equivalent exemption. It has a much more limited one, but it's only in the connection with an M&A transaction and can't be disclosed in any other kind of filing. And then we talked about the MJDS exemption in the U.S. The Canadian equivalent to that, Canada has an exemption. that allows U.S. incorporated companies and companies that have U.S. projects on those specific projects to be able to disclose exclusively based on the U.S. system, as long as they reconcile any material differences. The Canadian rules haven't been amended yet. They cover Guide 7. I would expect they will cover the new SEC rules, but technically I think that may be an open question at the moment.
But the rules are very similar. So I think for many companies that are 43101, many of them are also U.S. reporting companies, and so there's just going to fall within something that complies with both.
Okay. Then QPs. This is something everybody should focus on if they're subject to both regimes. So each country has some requirements for QPs that the other does not have. So in the U.S. requires that the organization of which you are a member must publish a list of all members. That is not in 43101. So if you are a 43101 QP or you're employing one, you're going to need to check whether the organization currently publishes a list of all members. And if it doesn't, you're going to need to make sure that they change their rules to do that within the next 2 years. Otherwise, you will cease to be a QP for U.S. purposes. Kim also talked about the fact that the U.S. 5-year experience rule is more specific than the 43101 one. And so you're going to need to assess whether there's a difference that's meaningful there and whether there may be some types of reports for which someone may not be a QP in the U.S., but they were a QP in Canada. On the Canadian side, 43101 requires specific education that the U.S. rule does not. So if you're in the U.S., you may not qualify up in Canada if you don't have the requisite degree.
Yeah, because it's based on academic or your academic credentials or experience, so that you could be purely experience-based and still be a QP in the United States.
Right, and then 43101 also does require that the QP be independent of the issuer in some circumstances, something that the U.S. rules don't require. We'll skip the part about naming individuals. I think we've talked about that already, but the U.S. side, you are specifically permitted to name only the engineering firm as long as the engineering firm is independent and as long as you do not name the individual QP. But it's not clear that 43101 fully permits that. So one of the things that will likely happen over the next couple of years is discussion back and forth between us and Canadian Council on what's permitted in each country and what is the easiest way to go about naming QPs so you're minimizing your consents. On the technical report side, the U.S. rules will require an initial assessment in order to declare a mineral resource. So that's more restrictive than 43101. That will mean that if you're a Canadian company that's going to have to comply with the SEC rules over the next 2 years, you're going to need to do that initial assessment to make sure you can still have your resource be declared in your SEC filings. But the SEC is more lenient in that it does not require a technical report prior to having resources. And we understand that 43101 requires technical reports on all material properties. If we get any of the Canadian rules wrong, by the way, please forgive us. We are not Canadian lawyers. We're just trying to make this as helpful as possible. So we attempted on our own, on a layman's basis, to review 43101. And you can beat us up afterward if we got some of these details not quite right.
As will our firm, because we're not permitted to practice Canadian law. So, all right, so preparing for implementation, it's 11:50. We're going to quickly run through these because we'd like to be able to get to a few of the questions. So essentially what it comes down to is the new SEC rules are much more detailed and much more specific than Industry Guide 7. I mean, Industry Guide 7 I think was 2.5 pages long in even relatively large type. And so this is much, much more detailed. It's much more technical. First thing you want to make sure to figure out is, do your QPs understand the rules? Do they understand that you want them to comply with the rules? If you've had, prior you only had 43-101, we've had this issue with some of our Canadian clients where they lost foreign private issuer status and they were going to have to become subject to Industry Guide 7. Even with ongoing technical reports they were doing, the QPs they were working with kept forgetting that they wanted them to comply with Industry Guide 7 as well. But this one, because it's so much more voluminous and encompassing, you want to make sure that your engineers, everyone preparing these reports, understands what they have to comply with. So we should expect, our guess is that, and this is a guess because the SEC is sort of a being in and of itself, we're expecting the SEC is going to review and comment on technical reports for form compliance. I'm guessing they're probably going to give people maybe a year before they start, lowering the hammer. And initially, it'll probably be commentary like, look, we don't understand X, you need to do X, Y, and Z. But significant deficiencies could stall or kill offerings or mergers. You have to be prepared for that. Underwriters are notoriously risk-averse in some aspects. So significant deficiencies in your disclosure, and the new disclosure when it comes into place, could create problems for you. So knowledgeable U.S. counsel, and you're speaking to them, can help you talk to the QPs and do form checks. Think of it this way. For those of you who are currently subject to 43-101, you have an intimate relationship with your Canadian counsel when it comes to reviewing 43-101 technical reports because they double-check them for you to make sure they comply. You will be able to spend that kind of quality time with us as soon as you actually start becoming subject to these rules. I know you're excited about that, I can tell. So in terms of for companies, if you're already subject to 43-101, kind of do a side-by-side comparison, talk to your QPs, make sure they qualify. If they don't, make sure that they are going to be in a position to qualify. Double check to see, if your resource and reserve estimates are going to be compatible. What kinds of amendments you're going to need to make to your technical reports. Many of the technical reports and the technical report summaries, they're really very similar. So we're expecting that if there's going to be changes, they probably are not going to be huge. And then what you want to do ultimately, if you're subject to both rules, is to make sure that your reports comply with both rules. And then if you're right now in MJDS and you're not going to be subject to this, it's going to be a question of kind of evaluating this to decide, if you actually want to try to comply with both rules or not. So U.S. companies that are not currently subject to 43-101, this is a whole new world for you. Again, it's going back to your QPs. Do they qualify? Both your internal and external advisors, do they qualify? Do you name your external QPs individually? If they work for you, they have to. Or if they're external, just name the firm. Strong recommendation, only name the firm. Prepared to make sure that your technical reports are complete and compliant. And then once you have resources, ta-da, you now can actually talk about them. So you're probably going to want to take advantage of that. So if you're a QP, check your credentials. Talk to your organization to make sure that they actually comply as well. Do you, with respect to the 5-year standards, is this going to limit the type of reports that you're qualified to work on? This is going to be a big deal, and this may be something that QPs have to focus primarily on. You've got 2 years to kind of get up to speed with these things. And then again, when it comes to that whole naming thing, firm versus individual, again, strongly recommend firm over individual. Let's see. So, and I think we've kind of hit on these pretty hard, but the big thing for these is going to be timing. So if you're preparing or updating the technical report prior to the effective date of the new rules, because technical reports, last for a period of time, you don't want to update them, that frequently. You may want to ensure that when you're preparing your technical reports on an ongoing basis, or possibly in 2020 or otherwise, that these will actually comply with the new rules, so that at the time when these rules go effective, and you're forced to comply with them, that you already do. Talk to your engineering firms. When you're dealing with your QPs, again, it goes to the question of consent. But, and this is going to be a question with respect to if you're subject to multiple jurisdictions in terms of who has to be named and how they have to be named. That's something to kind of sort through in advance, and so you're not having to scramble at a later time.
Yeah, and to the extent that you are complying early, the FCC has said they will allow companies to comply early and do the switch from Guide 7 over to the new rules once they've done some changes in the EDGAR system. So keep an eye out for announcement of that happening, and once that has happened, then you could not only prepare the report under the new rules, you could actually file it with the SEC.
So I would suggest possibly waiting for some additional guidance, but we do expect that they'll be putting out some FAQs at some point, because that might provide additional guidance to individuals regarding, to firms regarding, how these things are going to be effective, what kinds of reports it will be applying to and when.
And now we're going to try to answer a few questions. We may go a little bit over just to get some questions answered. But the first question is, can resources be used in a pre-feasibility study? So I think Kim went through that resources that are in the indicated or measured status can be used in a pre-feasibility study and converted into a reserve through that study. Yeah. Inferred resources, however, are not considered certain enough to be able to do that.
Yeah. And if you've seen the language the SEC currently requires people to put in there with respect to reserves, there's that cautionary note all about reserves. The SEC is very uneasy with inferred. So the second one is, how does a registrant determine if there's mining operations that are material? Materiality is, a question based on, is a fact and circumstance test with respect to any issue where you're going to have to analyze, what properties you have and, whether or not the issuer, based on fact and circumstances, actually considers the material. I don't recall that there's actually a threshold. It used to be the SEC said 10% or more was considered material for different kinds of operations.
Yeah, I believe they might have gotten rid of that threshold in the final rules. So I think that it's the standard for general materiality. But basically, if your name has resources, mining, gold, or any kind of other mineral in the name, it's material. But if you are a company that does primarily manufacturing and you happen to have a tiny bit of mining on the side, that's where I think you would look at it harder.
Or if it's a question of if you've got 3 operating mines and then you've got some other small exploration properties, I think clearly you can differentiate in those respects. So again, I'm sorry we can't give better guidance. Sorry.
So the next question was, do we expect that the technical report summary will be substantially different from 43-101? I think we covered that a little bit. We don't think there will be substantial differences, but there will be some. And so unfortunately, you will, if you are subject to both, you will have to really do a form check from both countries' perspective, because there will be different things in terms of what has to be covered and special legends and things like that.
Yeah, in terms of some of the differences in terminology, that might be taken care of based in like a glossary or something if it's effectively the same thing with different terms under the different rules. For the reserve and resource table comparison, does the comparison start with the second filing of subpart 1300 regulation SK, or do you have to compare the first subpart 1300 SK reserves and resources to the prior? Oh, okay. So in other words, do you compare the new rules against reserves under the old rules, or are you just starting with the new rules? I believe that you would only be, if you don't have prior subpart 13 rules, I think you would indicate that as opposed to putting in the old Guide 7 reserves.
That is an excellent question. I am very impressed by that question.
I know, actually, so am I. We should actually throw that one to the SEC. If you come up with questions where something is uncertain, the SEC is taking questions. They don't promise to answer them, and you may not see an answer to them for months, if at all, but they are curious as to people who are going through the rules and trying to understand them. So that is, I have to say, that is an excellent question. And then if you are a Canadian issuer who reports on U.S. forms as a U.S. issuer and you have properties located only in the United States, can that company be exempted from 43-101 and report under the new SEC rules only? That is going to be up to the Canadians, because if you are subject to reporting in Canada, and if Canada is subjecting 43-101 to you, the question will be if they permit a filer who reports on the U.S. forms to only comply with subpart 1300. So it wouldn't surprise me very much. Canada is a very, very common sense kind of a place. Yeah. So they may, but I don't think anything has been adopted yet.
Yeah, so we have to hedge our answer, but we do understand from reading 43-101 that it does have a provision that recognizes certain foreign codes as being acceptable, and if it's recognized as acceptable, you are in this situation allowed to report primarily under that code. You simply have to reconcile any material differences. So we think that you likely would be able to, but Canadian Council would have to give you the final word on that.
Yeah, and so the question would be, would you even still have to do the reconciliation? So, because there are some reciprocity rules from Canada and the United States that allows you to do one and not the other. So, and on that one, we just don't know the answer to it yet.
As an example, we have Canadian clients that I've seen disclosures that say their information is prepared in accordance with the SAMREC South African code, and there are no material differences between it and 43-101, and so it might look something like that.
Right. So, but unfortunately, we don't have a solid answer to that. But I think before companies become subject to this, that will end up getting fleshed out.
Yeah. All right, so that's the end of the questions that we had. So before we sign off, just want to give you key takeaways. If there's nothing else you remember from this, it's three things. One is make sure that your technical advisors qualify as QPs under the SEC rules if you are subject to them. The second is making sure that your technical reports will qualify under the SEC rules by the time that the rules take effect. And then third, just being aware that because the technical report requirement is long and complicated, that will all be subject now to an SEC U.S. form check review. So I'm happy to get involved as people are starting to work through that, to do the form check to make sure that when you file your report, it's good and you're not going to have an offering die or something else bad happen because you didn't get the report reviewed before the big deal.
And make sure that if you are hiring QPs, that they know under what codes that they should be preparing these reports. So
all right.
I think that's it.
That's it. Thank you, everyone. If you have any follow-up questions, feel free to email either of us.
Yeah, and thank you very much for taking your time today, and we appreciate your attendance.